Well, let's wait and see if somebody joins
Oh
in.
God.
So we are here now. I think we're live. Are we live? How do we know if we're live? Let's see if somebody joins in then. Oh, we have a couple of people coming in. I can see, and it's going to go into our attendees. We have 2 or 3 people joining in there now. So we're just going to give a little bit of time just to allow people to join. We have the fabulous William and Avril, and Sarah has just gone into hiding here from Peninsula. And Peninsula are a HR company who actually, do you know what, are actually Janette's husband's HR company, and they have looked after him for many, many years. Hence why we had the connection there. And you know us at Case Flower School, we only ever recommend people that we actually have experience in and that we know provides the service that people want. So we're absolutely delighted to have William and Avril here to give us all an insight into being an employer and being an employee as well. So it works both ways, and they are the experts. The Q&A box is open. Anybody that has questions, work away. Janette is here. Janette, come and say hello.
Hello, everyone. How are you? I'm on the sideline today for a change. This is definitely on my bracket. I don't know anything about HR. Well, I know a little bit, but definitely won't be able to solve anybody's problems. I'm more into solving your flower problems. So I'm on the side here having the cup of tea. I'm just after driving back from Sligo, so I'm a little bit tired, but I'm going to be listening in.
Okie dokie. And I just see an email just after coming in there. Somebody has deleted their link to the Zoom. Will you sort that out and send them on the link? Okay, without further ado, I'm actually going to hand over to Avril because they're going to control this webinar. You guys can see the questions if they come in, yeah?
Oh, yes, yeah.
You can? Super brilliant.
We've
any questions? Fire all the questions into the Q&A box. If we don't get to them all in this webinar, we will get Avril to connect with you and to answer any of your questions. I know they have a discount code for K's, so watch out for that as well. And I know Sarah did say she has a QR code at the end for getting in contact with them. So these are the experts. We're going to go off and leave them to you, Avril. It's all yours.
Oh, Deirdre, thank you so much. Thank you very, very much. And good evening, everybody. I just want to say thank you all so much for giving up your time this evening to give us a little ear. And I just want to thank Deirdre so much for inviting us along. It's a great opportunity to speak to so many of you. Very, very impressed with all the questions, by the way, you sent in. Might be a little bit longer than you thought, but look, we'll try and keep it as short as possible. So yes, so just obviously I'm Avril Donnelly. I'm a business development partner with Peninsula, and I'm here today with William, who will be doing most of the speaking today, but I'll just give you a little bit of introduction and a little bit of background about Peninsula. So William, if you can just bring up the next slide there, that would be great. So Peninsula would be the trusted partner with about 6,000 clients. It's growing all of the time in Ireland, and our aim is to basically keep our clients compliant. We like to see ourselves as a big business backup for the small business, because when it comes to employment law and health and safety, regardless of whether you have one staff member or 5,000, the law is the exact same. So we want to try and keep everybody on the straight and narrow and look after our people. Just like you guys are professionals, I don't think I'd like to throw my hand at trying to put a nice bouquet together. And that's your professionalism. Our professionalism is in employment law and health and safety, and we have our experts there for that. Just to give you a little bit of a snapshot, because just to tie in at the end, you might feel you need a little bit of help on this. So basically what we do for our clients is we're a channel by which they outsource this support. So you're basically getting a HR department, a health and safety department, and a legal department potentially at your disposal. We give you advice 24 hours a day. So we want you to concentrate and grow your business, and you can pick up the phone and ring us then at any hour of the day or night, and to ask us any question regarding employment law and health and safety, and we would back that up with all the letters, forms, documents, and everything that you need. The legal representation, it's quite unique to Peninsula insofar as that we protect all of our clients. So we cover them in tribunal representation. If they end up in a tribunal and they've followed our advice and terms and conditions are followed, obviously, we can cover them for up to 200,000 in one case or 2 million in 1 year. But don't feel you're getting value for money because we represented you in a tribunal. We're trying to keep you out of tribunal and out of trouble, but unfortunately you can't stop people bringing you there. And then health and safety, we would cover you for your legal representation for the same amount, up to 200,000 in one case, if you were ever brought to court by the Health and Safety Authority. Employee wellbeing is something we've introduced recently in the last few years. And we've actually now included this as part of our support. We used to actually charge a fee for it, but when COVID came, our managing director made the call and said, no, look, we need to look after our people. And this is a fantastic support for people where they have all sorts of things going on in the personal life, financial matters, legal matters, debt matters, childcare, elderly care. People have issues like drugs, alcohol. Any of your employees could come across this. So this is basically a support line that they can pick up the phone and ring a professional, and they can speak to a professional and get the advice and support, so that they're not leaning on their employer, who may not be qualified either in those areas. And they can get 6 face-to-face counselling sessions with a clinical psychologist, and they can speak to a nurse 24 hours a day. And you can ring up about anything to do from granny's pension to, a nurse that your child is sick. Bespoke HR documentation. I think if you get nothing else out of this event this evening, you will realise the importance of tailoring your documents. I just come across it all the time. I'm a long time in this game, and I see where employers, and they may have even had an inspection from the likes of a WRC inspector. So they'll have all the boxes ticked from a legal perspective, but from a business perspective, they haven't protected themselves with particular policies. But William is going to cover them in great detail as we go, as we get into the event. And then finally, we've got our HR and health and safety software. So within that, we're developing it all the time. We've got training courses for staff for health and safety, for employment law. We also have things like a clocking system. You'll discover as well that you have to keep a record of start time, finishing times and break times, holiday planners, and all sorts of little tools, employee files, to help you manage your business. And that's what it is, to help manage your business in the easiest way possible. So we'll just move on to the next slide there, William, if you wouldn't mind, please. Perfect. So our agenda for today is we're going to cover the essential elements of your employment contracts and your policies. A lot of questions come up about contracts and handbooks. Employment litigation changes. They are changing all of the time, but particularly in the last year, there has been a few. So we'll cover all of those for you to keep you up to date. Health and safety checklist. We'll do a little checklist just to make sure what you have in place, what you need to have in place if you were, inspected by the health and safety officer. So we'll do what you have, what you need to have in place, and we can also cover the consequences of not having it in place, if you like, as well. And then we will cover all of your questions at the end. So I'm now going to pass you off to William. Thank you very much.
Evening, everyone. How are you doing? And I suppose thanks to Everald for the introduction. This evening's session is on contracts of employment and the importance of contracts of employment in the area of employer-employee, and probably we'll get to at some stage some of the difficulties that can arise when these contracts are not in place. So I suppose, starting off, what is a contract of employment? Well, a contract of employment is an agreement between an employer and an employee that stipulates the terms and conditions of the employment that they will have between each other. Now, it's very important. This is your Bible. It's very important to set out exactly what you determine your relationship is going to be with your employee, because at later stages in the employment, when people get used to each other, things can go wrong. It's one thing that you can refer back to from the get-go. You've got this contract. It's to be given to the employee within 1 month of starting. It used to be within 2 months of starting, but it's now 1 month, and it must cover a certain amount of items as per the Terms of Employment Information Act. I'm not going to get into any technicalities, but it's very important that this is given to an employee. Changes in law since 2018 now also provide that an employee is entitled to get a statement of their core terms. From 2018 on up to start of this year, it was 5 core terms. Now it's 10, to include things like name and address, probationary period, rates of pay, just to name a few. So there are 2 things that are so important to have in place before an employee starts. What's involved in a contract, and is it a contract? So what's involved is statutory terms. They're terms set by the Oireachtas. Employed terms such as customer practice. Another employed term in a contract of employment is that you'll actually pay wages. Another employed term in a contract of employment is trust and confidence, that you must trust and have confidence in your employee, and that's a two-way street. They'll have contractual terms such as, say, a probationary period, such as notice periods, or any incorporated terms that you so wish to have in that. So just say, for instance, you had a probationary period. I would suggest that the probationary period is, apart from being in the core terms, your 5-day statement, but it would be essential to have that in your statement of the main terms, your contract, your main contract, just stipulating what notice periods are applicable in that probationary period, so that if any issues arose at a later stage, well, you can refer back again. This is what we agreed on. This is what these were the terms upon which I was prepared to contract with you. And remember, you as the business person would be considered to be more business savvy than the employee. So it's a matter for you to have these matters in place. It's also a matter, and here's the difference, I suppose, between a statement and a contract. It's a matter for you to sign the statement, but it's not a matter for the employee to sign the statement. They just need to sign something to say that they received it, or if they do sign the statement, that's fine. Just make sure that you have evidence that you gave it to them, and that may be either be an email, a receipt, or they actually signed it and dated it and handed it back to you. I'll touch on this later on, because I see there's a couple of questions in that'll help answer that. So the Miscellaneous Provisions Act 2018, as I've just said, introduced the right to a 5-day statement of the core terms and conditions of employment. So all employers must provide a statement of core terms within 5 days of starting. So what's the implication of some employer not providing those, a 5-day statement or a 1-month statement? So the implications of that is, if, say, for instance, there was a falling out between the parties, and the employee went to, say, the Workplace Relations Commission and said, I never got a contract, they would be advised that they should have been given a 5-day statement and a 1-month statement. And they would also be advised that they could take a claim to the WRC that the employer was in breach of the Terms of Employment Information Act. And as the form is fairly easy filled out, the penalty for not giving an employee a 5-day statement or a 1-month statement is 4 weeks per statement, 4 weeks pay per statement. So you could be down 2 months' wages for not giving an employee either statement or both statements. So it's so important to have these in place before, I would suggest, before the employee starts. I see there was a question in terms of what's an employee handbook. An employee handbook, I would put to you, is a Bible. So the employee handbook will have policies, procedures, which you will rely on at a later stage, if need be, if some issue arises, say in terms of data protection, say in terms of a grievance, of disciplinary issues, dress codes, use of mobile phones, you name it, you can put whatever you want that you want in a handbook, you can put into it, that will offer you assistance and the employee assistance should any issues arise at a later stage. So here you are, your employee handbook and policies establish rules and boundaries in your workplace. They help ensure that any staff issues are handled consistently, and make sure there's no confusion over conduct. So confusion over conduct. In an employee handbook, you'll have a disciplinary procedure, and it'll state for the employee what we consider as minor misconduct or gross misconduct. We'll also state in that, like, what sanctions we can offer or what sanctions we can give in relation to minor conduct or in relation to gross misconduct. Your handbook should also include policy. So here we are, disciplinary procedures or grievance procedures and how staff can report concerns or issues. Grievance procedures and disciplinary procedures are extremely important. So for instance, if an employee was to say Well, I wasn't aware that there was a grievance procedure, so I couldn't raise a grievance. And because the employer didn't pay me, or because the employer failed to give me my holidays, or for whatever reason, I dismissed myself. I considered my contract was terminated. That employee has a good chance of securing an award down to WRC because no grievance procedure was shown to the employee or given to the employee at the stage upon which he or she needed to use that. So it is so important that we have grievance procedures and disciplinary procedures in our staff handbook. Examples of policies other than that. So you'll have wages, salary, you'll have media, a right to search, wastage policy. Wastage policy is a good one. Dress policy, I see there's a question on people turning up in certain dress codes. A mobile phone policy. I see there's another question on workers using mobile phones during the day. Confidentiality, competition policy. There was another question in relation to one of the employees taking pictures and putting them up as her own or his own work. Excuse me, lateness policy. You can have all sorts of policies in it. This one here, CCTV policy, and I'm just going to bring you back to a disciplinary policy and the CCTV policy. So if we had, say, an employee and the employee was taken from us. So in other words, they're dipping their hand in the till or whatever the case may be, they're taking property from the employer. If we do not have in our policies that we can use CCTV footage in a disciplinary, well, then we can't use it. It must state it quite clearly and unambiguously that we can use that CCTV coverage coverage in any disciplinary matter. So that's the importance of it. They're things when you come to a WRC hearing that if they're not in place, you'll find yourself in trouble.
Yeah. Can I just give an example of that, William? Just I think it's just to zone in on it. So I had a situation in a retail outlet where there was an employee caught stealing, and they were arrested by the guards, charged, came into work when they were released, and the employer fired him because he stole from him. The employee then went on to bring a case against the employer. I went down and I met with the employer after that, and I said to him, I said, well, why did you fire him? And he said to me, well, the guards found him guilty. And I said, yes, that's criminal law. This is employment law. And I said, was it the cameras? And he said, yeah, that's why he ended up paying the award. He had to pay that employee €15,000 after that employee stole from him. So that will just give you an example. And that's why I was saying at the start about the tailoring of the documents. So I'll let you continue there, William.
That's all right. Yeah, no, they're always good. Like Evelyn, like Avril, they are always good to give those examples because that's what really happens. That's what happens in real life. I can give you umpteen examples of employers failing in procedures and costing them. One I can recall costing 48,000. So now it's not that every case will be big sums like that. You know, there's different factors taken into consideration. But anyway, changes in legislation. So the Transparent and Predictable Working Conditions Regulations 2022. So this aims to provide more security to employers in precarious forms of employment, like, you know, temporary contracts or gig economy. Now, gig economy, you'll always find in gig economy that most of the people in the gig economy are self-employed. So under the Workplace Relations Act 2015, you must be an employee to take a case into the WRC. However, and there's always a but or a however, an employee could say, or a worker could say, well, actually, I should have been considered as an employee and not a self-employed person. And now you're really, you know, there's a case to be answered. They'll hear it at the WRC, and you could expend a certain amount of money, a couple of thousand, just defending that piece. It could be found that no, you're actually a self-employed person, but you've had to put out money to actually defend that claim. So albeit I say that they're self-employed workers, not always the case. So here are some of the acts that have been amended because of the regulations, 22 regulations. So the Terms of Employment Information Act 94. So that now provides that there's 10 elements to the 5-day statement or the 5-day contract. Organisation of Working Time Act in terms of leave, the Protection of Employees Fixed Term Work, or the Workplace Relations Act 2015. So update on the probationary period, a 6-month limit on the length of probationary periods has been introduced. So you can't, there are instances where you can go beyond that, but you have to be very clear in what you're saying and very clear as to why the period must be extended beyond 6 months. Employees on probationary period exceeding 6 months will be deemed to have passed their probationary period, yes. So in contracts of employment, you will see, there will be a 6-month probationary period. This could end up as a 9-month probationary period. You will not be considered as past your probationary period unless you've been informed of, right? So this changes that. Work-Life Balance and Miscellaneous Provisions Act. So here we are, 5 days. Unpaid leave for medical care purposes. I think I'm right. Unpaid leave for medical care purposes for parents of children under 12 and carers. You'll have 5 days paid leave for victims of domestic violence. Now, this is paid leave. Up until this act, there was only a number of items that were paid leave. One was annual leave, public holidays, and sick pay since 2022. Sick pay was a paid leave. Maternity leave was not. Maternity leave is a benefit. You do have a right to maternity leave, but it's not paid by the employer. What else has the work-life balance? So you have a right to, yes, you have a right to request flexible working for parents and carers, and then you also have a right to request to remote working for all employees. That's obviously that's dependent upon the type of employment that you're in. It's not a given that that every time that you request the right to remote working that you'll be given that right. That's not what the act is about. Also, sorry now. Breastfeeding breaks extended to 2 years. So what does that mean? Well, I suppose what that means is we have to provide as employers to our employees who have just given birth and who are breastfeeding. We have to provide a facility in the employment where they can go in and they can express in a private area. And what does that mean? Well, to me, what that means is that we have a room with a fridge, somewhere to sit, somewhere that's clean, and it's respectable. That's what that means to me. So it's gone from 6 months to 2 years. Now, look, you may have people jumping up and down saying, well, God, that's an awful lot to offer. But if, for instance, I'll example it this way for you. If we want the best of the best, well, then we have to provide the best. The Irish Congress of Trade Unions carried out a survey about 4 or 5 years ago and found that 52% of the workforce were women. I'd say that's probably risen to about 55, 56, even 57% of the workforce is women. So why would we not provide that? Like our mothers, our sisters, our daughters, our wives, why would we not provide that to them? Sick leave. So the Sick Leave Act of 22 at the moment, there's 3 days statutory sick leave, and that rises then from this year up to 24, 25, 26. And in the year 26, it will be 10 days. It's 10 days at 70% of the employee's daily rate, up to €110 per day. That's what it is. Here it is, 3 days sick leave in 23, 5 and 24, 7 and 25, and 10 and 26. So they are just some of the changes in legislation that have come about, say, in the last 2 years that employers need to be aware of. Because of the industry that you're in, there is no employment regulation orders, nor is there any sectoral employment orders or registered employment agreements, to my knowledge, that exist. They would provide beyond statutory provisions to employees working in particular sectors, but there's nothing in the retail sector or in your sector that provides additional terms and conditions of employment, be it any of the avenues that I've just mentioned. So look, I think the next section is on health and safety. So I'm going to hand that over to Avril, and she'll take you through the next couple of slides.
All right, thanks, William. If you could just bring up the slide for me there, that would be great. And we can jump on to the next one. Lovely, great. So you can see again there, guys, we've got the Safety, Health and Welfare at Work Act 2005. So like all the other acts, once you see Act, it's obviously something that you have to, comply with, and you have to make sure that you have everything in order. So I would always say about health and safety, 3 things to consider. Why do you need a really good health and safety system in place? So the first reason is your insurance. I would hope that everybody has insurance for their businesses, and your public liability. So it's like, I suppose if you look at it and compare it to maybe a car where a lot of us would drive, you have your car is insured, but we all know that in order for your insurance to stand up, you need to make sure that your car is serviced regularly, that you've got an up-to-date driver license, that your tyres in good working order, etc. Your business is the exact same. There are certain boxes that you need to tick. So we will cover that, and that's where we'll do the little checklist. Then the other reason would be that you could have an inspection by the health and safety officer. And actually, I have done quite a lot of floral shops, and they may have not even any staff. Some of them are maybe just the business owners themselves, whatever, but they still need to make sure that their health and safety is all in good order, because they could get an inspection, and they've got the public coming in all of the time as well. So anybody could slip, trip, fall. And the Health and Safety Authority, they can come out and they can check to see, have you got your safety statement, all your documentation in place? They're not just looking for a bag of books. So guys, you need to be aware of this. They want to make sure that you are taking it seriously. So what we're saying is that, as you can see there, every employer shall ensure as far as reasonably practicable the safety, health and welfare at work of his employees. And you also have to take into consideration the public as well. And the third is the most important reason, because you want to keep people safe. That's why you want a really, really good safety system in place. And you want to have the peace of mind. Like, people will have accidents, people will do silly things. You can't stop accidents happening, entirely, I wouldn't say. But what you can do is make sure that you've made every reasonable effort to try and avoid it. So you want to have the confidence to be able to say that, okay, at least I know I had everything done, and I'll have my house in order. So we'll move on to the next slide there, William, please. Thank you. So your legal requirement as an employer, you need to appoint a competent person. So if I was the health and safety officer and I walked into your premises in the morning, I can want to see the competent person, talk to the competent person. It could be the business owner, but you need to make sure that if you're not there, that there is always somebody there who's classed as a competent person. And they would be able to talk the inspector through, where the documents are. They might ask some random questions like, when did you do your fire drills last? When were your first aid kits up to date? Where's your training records, etc. You need to be able to produce that safety statement. And the safety statement is like, the statement itself is a one-pager, but it's to say that you've got all of the system in place. So it's to make sure that you have everything else covered. You've identified the hazards for your business. Sometimes I do go out to companies and they've taken the photocopy of the documents from a company similar to themselves. You should never ever do that, guys. This has to be very specific to your business, and you've assessed all the risks. So that's what we're talking about, risk assessments. And if anybody doesn't know what a risk assessment is, it's basically where you're identifying a risk in the business, and then you need to be able to say to your employees, this is the risk, but this is how you avoid it, and that you have absolutely roll that out to the staff, and that they've got access to all of that information. It can be anything from, handling a scissors. It could be slips, trips, falls. William was saying there about the amount of females working in businesses. You need to make sure that you've got, a pregnancy risk assessment. So you're putting the onus on a lead to come and tell you they're pregnant, and then you need to do a risk assessment with them every trimester. So like, how often do they, are they to take rest periods, etc. We've about 668 risk assessments already preloaded onto our system, so we could be here till the cows come home going through them all. But you need to make sure that they are covering your business. One florist might have stairs, another one doesn't, so they're never identical. Make the arrangements that you need to make in place. Have you got, whatever training is covered? Have you got your PPE necessary for your business in place? And then record any significant findings from, when you're doing your annual inspections, etc. And you're keeping an eye on everything for your business. We move on to the next slide there, William, please. Thank you. So what are the duties of the employee? They must take reasonable care of themselves and others who may be affected by their actions. They have to cooperate with their employer. They need to ensure the health and safety criteria is met. Not to intentionally or recklessly interfere with anything provided in the interest of safety and the use of safety equipment provided as instructed, so that they must follow the instructions. But you must roll that out to them, and it has to be in writing. Always remember, with health and safety, it has to be in writing. And that you're putting the duty on them to report any illness or condition that may affect themselves or any other employees or any other people, and that if there's anything medical that is recommended, that they need to inform their employer by their GP, that they must let them know. Thanks, William. So remember, you have the responsibility of health and safety for basically everybody, but there's a few listed there: your visitors, your customers, your employees, your contractors, your volunteers, work experience. Another thing I would just say to you as well, if you're not on the premises, make sure that whoever's in charge and your competent people know. If they're trained up properly, they will know this. If anybody has an accident, no matter how minor, always record it. If anybody walks out and says, I'm fine, no. You need to record it, keep it on file, because they have 2 years to put in a claim after that accident happens, okay? And a lot of the time that does happen, where people say, sure, I'm fine, because it's only a small little accident. So just bear that in mind. We'll move on to the next slide there, William, please. Thank you. Okay. So the safety statement is created and maintained by a competent person with the necessary knowledge, experience, qualifications and resources. So Peninsula will be a certified body. We can prepare these documents for our clients, and we actually give them a letter then that they can submit to their insurance company, a letter of competency to say that they have all of this in order and in place. So the policy must contain the safety statement, the general policy and the arrangements that you have in place, the structure of individual responsibilities and roles, a programme of risk assessments, including a fire risk assessment. That would be standard in all businesses. And then, as I said, there's numerous other risk assessments that a business should have. Just a couple that I would mention to you as well, or a couple of things from the floral industry point of view. You might have people who are working alone. You might need a lone workers policy. You might have aggression in the workplace, where somebody's come in and they're quite aggressive with your employees. You have to remember, your employees are entitled to come into work in one piece, happy and healthy, and going home happy and healthy. You probably have things there like thorns on bushes, etc. So that's something that you need to make sure that if anybody gets any sort of a cut or a prod or anything like that, that it's, that they're taking the correct medical procedures to follow on from that as well, and that you've got adequate training in place as well. So a program of the risk assessment, and then a program of demonstrating how compliance will be monitored. So again, you need to make sure that all of your tasks, we would have a system again that you would remind you what your tasks are, so you can get on and focus on your main business and core business, and that you can just log on and you can see what you need to do, when you need to do it, and who it's been assigned to if it's a bigger organization. Perfect. So here's a little checklist just to make sure that you've covered everything, guys. So I would ask you to maybe after today go back and have a look at what you have in place. Make sure that that safety statement is in date. It has to be up to date every year. So your policies and procedures. Have you given your staff an employment safety handbook as well? A lot of times when I go out and I meet with business owners and they say, oh yeah, I have a handbook, and it's the employment handbook that they give me. You have to have an employment handbook, safety handbook, and you have to put the onus give that to the employee. So you're basically telling them what the law requires of them as well. So standard operating procedures, do they exist? When were they last updated? Do you have proof that they were shared with staff? We do that through our app, so they can never say they never got it. Your risk assessments, I think we've well covered that. Another thing as well, just because you guys will probably, now some of you might have contracted workers doing it, but because you're doing deliveries, do you have a driver's risk assessment? Do you have a driver's handbook? And a policy for driving in the workplace as well. This is where the linkage is with employment law and health and safety, because we actually have a vehicle policy in the employment law handbook as well. It's a driver license. You're putting the onus on your employees to come and tell you that the driver license is in date, how many penalty points they have, and what the procedure is if they get fines, etc. You don't want to be paying out for them. Speeding tickets, etc. Training, manual handling, fire awareness, driving for work. If they're lifting up heavy materials, they would probably have to get the physical and manual handling course done. That needs to be done once every 3 years. We have numerous free online courses on our software as well. General overview on health and safety, loads of things that you need to cover there. Monitoring your workplace, what work they're actually doing, and then the hours of work. I think Billy's covered that under the Working Time Act, that you're keeping a record of start time, finishing times, and break times. Coming along to it there in the last slide there as well. So the register of records, the working time, that can you show that they've taken all their holidays, their rest periods, and then bullying and protect code of practice. Just be very careful of that, guys. It's very simple for somebody to say, I was harassed, I was bullied. Don't assume that what you've been told is correct either. You always have to do an investigation. Somebody could be making a false allegation there as well. But you just need to make sure that you've got a really good harassment and bullying policy in place. And you're putting the onus on anybody to come and tell you. And then you will deal with it in the correct manner. And then that they're signing in for training. So if you're doing any training with staff, make sure that they're signing in for that as well. So we've got loads of questions. We've run over a little bit, so we better fly through them. And thank you very much. I've just given you the quick version there. So I have the questions here. Billy, I think most of these are covering employment law. So if I call them out to you, you might be able to help us. Yep. So the first one, we probably have covered a lot of them already, but we'll fly through them there anyway. So do I have to give a contract to an employee?
Yes, without a doubt. So,
yeah.
Yep, absolutely.
Yep. Do you give it to them when offering the job?
So the offer letter goes out, offer letter comes back signed, dated, contracts then go out to the prospective employee, and they need to be back in the office or back at the employment before they start. Now, it doesn't essentially have to be that way, but my I suppose opinion would be that's the best way of doing it.
Yep, perfect.
Yep.
I have a florist working for me over a year. To be honest, she was brilliant. But lately she's doing nothing in work, not pulling her weight, and I want to get rid of her. How do I go about it?
Okay, so you can performance plan, put a performance plan in place. Have you got a policy on it? Have you got an employee handbook that you can refer to? Have you brought this up with the employee? You know, there's so much here now that needs to be done, because if you start making allegations against the employee that are not pulling their weight, so you're at, say, a fora like the WRC, dates upon which that happened. What did you say? Did you have a meeting? Did you invite them to a meeting? Did you tell them what the issues were? So there's so much involved in that. You would want to be very careful how you done that. To me, the best way to do it is performance managers, but it must be documented as to when and what you did in relation to your employee. So, you know, you need to improve here, and here, and we're going to come back in a month's time or 2 weeks' time. That hasn't happened. This has. So you need to improve here, and here. And, you know, there are various ways of doing it, but it's something to be really careful of, you know, of how it's done. If you are going to get involved in something like that, you will need assistance from the likes of ourselves in finalising something like that. So I wouldn't go about that on my own.
Okay, all right. Very good. Next one, I'd say a few people have come across something similar to this. So a florist that I have employed refuses to wash buckets and floors, etc. She says that she's employed as a florist, not a cleaner. But I need her to do both, as they're a two-man shop, and can't afford another wage.
Yeah, so I suppose, look, that's part of her job, or that's part of his job. So, you know, you could bring that up with them straight out, that, look, this is part of your job to do, and I expect you to do it. I suppose in regards to health and safety, well, that's everybody's, I suppose, responsibility, including an employee, and even employees have a duty of care to themselves to act reasonably in their employment. So good housekeeping and a good housekeeping policy would be essential here. If you don't have anything like that, look, we can absolutely assist you here in relation to that, and I would caution going about this aggressively. I would step by step, tiny steps, deal with something like that.
Okay. Very good. Actually, just on that, guys, you can see on the screen there, if you have any other questions, just you see the QR code there, and we're happy to come back to you. You'll see my number there as well, so you can contact me directly or email me as well. So please don't feel overwhelmed by anything after today. Obviously, these are just a couple of questions that people have sent in, and you might have more yourself, and you will obviously get a complimentary one-to-one with myself as well if you feel that you need a little bit of help. So next one then. Okay. So my florist refuses to work overtime coming up to the likes of Christmas, Valentine's, Mother's Day, and what can I do?
So is it in her contract that you may be asked to work overtime? Has she worked overtime, or has he worked overtime up to this, and what's the reason for not working overtime? So is there a specific reason, say, got to do at home, or got to do with, say, a family structure at home where she's a carer, or she has a child or a husband who needs her care, or he has a wife who's pregnant, and he's acting as carer? Because if you were to push an issue here, you could be found to be discriminating against somebody on the grounds of family status. So and the awards and family status are 40,000 or 2 years' pay, whichever is the highest. So you need to be cautious as to why they're not working overtime. And if it's just overtime coming up to busy times, why is that? So you need to ask and probe here before you do anything.
Perfect. My florist is looking for a large wage increase, but I can't afford it. She says that she's entitled to a wage increase every year.
Quite simply, no, that's false. No.
Sorry, were you going to say something else, Evan?
No, that's it. You're not getting it. End of. No, you're not entitled to a wage increase. No.
How do I deal with someone coming in late every day and taking longer breaks than she's allowed?
Okay, so you need to address it with them. You need to have the dates. You need to invite them to a meeting. You need to say, I have an issue with you turning up late, and I don't want it to happen again. And that's it. That's the first one. Second one, you say, okay, you're inviting them in again. You're telling them why you're inviting them in again on paper, and you're saying, okay, so I've said it to you before about turning up late. Now I'm saying it to you again. What was your reasons? Go through what the reasons were. Take time out then to decide as to what you're going to do. An issue here in terms of disciplinary, and I won't talk too long on it, but an issue here in terms of disciplinary, a person investigating a matter can't then go along and decide upon a matter. And then if that employee decides, well, I'm going to appeal that decision by my employer, the same person who investigated the matter, the same person who disciplined me on the matter, that same person can't hear the appeal. It has to be somebody else impartial. So again, before you do anything, you need to give us the exact details of what the issues are. And if it's just something straightforward as that, you need to be quite clear in what you're saying. Your contract says you're starting at 8 or you're starting at 9, wherever it is. And, you may need to draft in somebody if it does get serious down the line where you really have to discipline someone.
Absolutely, yeah. I think what a lot of people don't realise is that, the documentation is absolutely so important. That's the first step. But equally as important is the process you follow. And if you get nothing else out of today, guys, we see so many cases lost on technicalities. And that's a typical one there, where somebody was down to do the verbal warning and somebody else did it instead. If you don't back a verbal warning in writing, that's another technicality. I think one of the ones that I thought was ridiculous, but it happened, and it was where a HR manager wrote disciplinary letter perfectly, but she left the word discipline out of the title. And when it went to the tribunal, it was deemed that on a technicality, that employee did not get a disciplinary letter and the process was flawed, and therefore got an award of €30,000. So it just, be always careful, and that's why we have the advice 24 hours a day that people pick up the phone and rings. Just on the lateness as well, like you can write the policies whatever way suits your business, and another way to overcome that would be, you could say that If you're late, you phone in, you don't send a text message, and if you arrive for work more than 15 or 20 minutes late, your job might be re-signed and you might be asked to go home from work without pay. Now, sometimes employers say to me, but that sounds a bit harsh. And I say, no, it's not harsh. You're not saying it's not acceptable you're 15 minutes late. You're saying it's not acceptable you didn't have the common courtesy to pick up the phone and ring me and tell me you were going to be 15 minutes late. Of course, people have things going on that sometimes lend them to be late from time to time. And most employers are quite reasonable with that. Anyways, well, let's move on to the next one there. Community grant. Yeah. Can you request to your employees not, oh yeah, I love this one, not to use a personal mobile phone or social media during working hours?
You can, yeah. Do you want to answer that, Avril? Yeah, you like that one. Do you want to answer that?
Well, yeah, it's just that, like, I mean, you need to have the policy in place there, right? Like, and sometimes people, and you know, a typical one, like, I had a situation in a hair salon where a girl did a bride's hair, did a fabulous job, put it up on Facebook, not meaning to do any harm or anything to the employer, but the bride got wind of it. It was in a small village and went ballistic at the employer. Your business is potentially the same, where somebody's putting up their work or whatever. And I think we actually have another question similar to that coming up later on. So anything that they post on social media, you have control of that. Once it's to do with the work, but guys, your employees are coming in to work 9 to 5 or whatever the hours are to do an honest day's work for an honest day's pay to the best of their ability, take their breaks, go home happy and healthy. That's all you want. There is nothing that they should be doing that's diverting from that in the course of their work. So absolutely, you can say, leave the mobile phones in the bag. For emergencies, they can either phone your mobile number or the landline, etc. So again, you have complete control of that. Yeah, thank you. Now, next question. So my part-timer says that she's entitled to full wages on bank holidays, even though she works on a Saturday, not Monday.
Yeah, no. So if she works or he works 40 hours in the previous 5 weeks, he will be entitled to a fifth of their wages for that bank holiday. That's it.
How many days holidays is a florist entitled to if she works full-time?
So he's working full-time, 39 hours a week. He be entitled to 20 days.
Okay. One of my employees comes to work inappropriately dressed, as in untidy and dirty clothes. And how can I deal with this?
Yeah, so we can have a dress code. Yeah, and you need to have it in your employee handbook, and it can be addressed there through our procedures. Yeah.
Yeah.
So
you'll have the. Yeah, and then you link it to the disciplinary process then. So if they're continuing to come in, so it might be something like failure to follow your rules, procedures or instruction as well. So you need to tie it in with that if you're going to follow through in any disciplinary. This is kind of similar to what I was saying. I think we might have covered it. So one of my employers takes photos of her work as her arrangements she makes of the arrangements that she makes in the employer's shop while I'm paying her, and post them on the social media. I think we've kind of covered that from the last one. Yes, you can absolutely stop that. My employee advertises that she sells flowers and Christmas wreaths coming up to Christmas. She works for me full time, but does this as a sideline. And I feel it's affecting my business, and she's undercutting the job's prices as well. Oh gosh, yeah. And then I suspect that she's not paying tax for this work as well, and can I request that she does not do this?
Yes, absolutely, because it's in direct competition with yourself.
Gross misconduct most of the time.
Yeah, it would be gross misconduct, but again, you have to have that in place in a procedure, in a policy, in your employment handbook. And she needs to know it as to what disciplinary action that you can take for her carrying out that type of behaviour. That is gross misconduct.
Yeah, absolutely. Guys, you have to protect your business and your bottom line. And that's like a lot of these policies. That's why I'm saying there's certain policies that are there from a legal compliance point of view, but from the ones that protect your business, there are all these other ones that you need to look at, that you need to have in place. But yeah, absolutely. And under the Working Time Act, there is a link there with health and safety, because you need to put the onus on employees to come and tell you if they have any other job. And I will also say, like, how confident are you? And I'm not saying that they are, but how confident are you that they're not using your little tools and materials as well to, so I've seen stats that 80% of employees that steal in companies that the people you least expect hope none of you guys are the victims of that, but just be mindful of that as well. I have florists working for me, and when I'm not there, they do absolutely no work. I know that they stand around talking. I've had made a list of what jobs that they have to do, but they basically don't do them. They just ignore it.
Okay, so you can discipline your employee for not working. So they're there, as Avril said earlier on, you're there from 9 to 5, you're there to work for them. And so if they're not carrying out their duties, you can actually discipline them. You can put them on a performance plan and you can performance manage them out. Or if it gets real serious, well then, you know, through the disciplinary process, they can be dismissed. But again, your procedures have to be correct. Because if you dismiss somebody, it won't be it won't be them that's questioned at the WRC for what they did. It'll be you that'll be questioned at the WRC for what you did as an employer. Yep,
I think we kind of covered this there 2 points ago, but it says, I suspect that one of my employees is helping herself to cash and materials in the shop, and how do I approach this with her?
With caution. So you have to make the allegation. The big word here is allegation. It's just merely an allegation. You would invite her to, and this is a serious allegation because this could involve a criminal matter. So you have to afford them natural justice and fair procedures in how you deal with them. So you'd invite them to an investigation meeting, and you'd have to put the allegations to them in writing before they come to that meeting. After that meeting, if you found that there is enough probable cause here to suspend them and deal with it in a disciplinary, you can suspend them on full pay pending the investigation and pending the outcome of the disciplinary, and you would have to follow a procedure. If you didn't follow a procedure, you could be found wanting down at the WRC, and it may cost you money, a lot more than she was helping herself to, or he was helping himself to.
Yeah, and you know what? Just to try and avoid that happening in the first place, put a negligence or a right to search policy in place if you wish, right? And a right to search policy, because when you hire a new employee, do an induction with them, read the handbook, give them the handbook, read through it with them, because once people read it, they're actually they will say to themselves, "God, I'm not going to steal from that company," or whatever. Well, you'd like to think that they would, but look, it's some sort of a deterrent anyway. And you're saying that we do have the right to carry out random searches. It doesn't imply suspicion or guilt. You do have the right to have somebody else there if practicable. We do have the right to call in the Gardaí, and it may result in disciplinary action or something. But again, proceed with caution, as William said. My employee told me that I can give her €1,000. Give her €1,000 a year without paying tax on it.
Yeah, she can give it to her in a voucher. You can do that, but no other way.
Okay. My employee wants me. My employee wants me to pay her cash, as she's also claiming benefits.
No, problem here is the contract now is tainted with illegality on the basis that you know that she's claiming benefits. Now, are the benefits for work? Are the unemployment benefits? What are the childcare benefits? I don't know. But if you start paying your employee cash, your contract then is tainted with illegality, and it has no relevance anywhere.
Okay.
Yep.
Now we've got a health and safety one. My florist fell off a ladder at work. Now she's grand, but no doctor visit, etc. And now she's talking about claiming. This is what I was saying earlier on. Don't assume when people say they're grand at the time. Always take it as if a claim is happening. Just assume that a claim is happening. So what you would have to see. Just check out, has there been an accident report filled out? You need to do that. Was there photos taken of the accident? Again, on the app that we have, you can actually do it on the app. So even if you're not there, whoever is working can do it. Did they get witness statements? This can not always be see what people see and hear. Yeah. Have you looked at the ladder? Have you done a risk assessment for it? Falling from height risk assessment as well. And have you put into place an action plan to investigate the accident and put in place corrective action? And have you taken the ladder out of commission and sorted and labelled to make sure that nobody uses it again? There's just a few of the little things that you need to put in place. But yeah, just anything else you want to add on that one, William?
No, you've said it. You've accident report filled out, notified whoever you need to notify. If you do need to notify the HSA, witness statements, photographs. Yep. No, you've covered all the angles there, Avril. Yep.
Just something that people might not be aware of as well. If anybody has a work-related injury and they're out sick for 3 days or more, you're obligated to contact the Health and Safety Authority within 10 days. Okay. My employer refuses to lift buckets of water and boxes of flowers, and she said that she has a bad back. But she's no benefit to me if she can't do these jobs, and they want to get rid of her basically. So it's kind of an employment law and health and safety question, isn't it?
It is both, yeah. So like you look at things like, is there training done like manual handling?
Yeah,
right?
manual handling.
So is there individual, say, risk assessment in relation to loads and all that sort of stuff? Is there a method statement on how to, how to lift, correct techniques, all that sort of stuff? So there's also a question here in terms of capabilities of actually doing the job. So is this employee capable of doing the job? And one of the reasons that you can dismiss where a dismissal can be found or deemed to be fair is on competencies or their ability to do the job. So if they're not able to do the job, well, then you're not, expected to give them work. Another reason would be frustration of contracts. So say you have a driver and that driver has had, say, a driving ban. Well, that's another plausible reason to let somebody go. But it's up to you. And if you remember what I said at the start, you are the employer, you are a bit more business savvy than the employee. It's up to you to have all these procedures in place and for you to know what to do, not the employee. So that's just some of the issues now that I would mention in relation to that. Again, caution in how you deal with this employee.
Okay. Do you have to pay an employee's wages when they just ring in and say that they're taking a sick day?
No, unless it's expressed in the contract. Is there something in the contract that says, you have so many uncertified sick days as they do in the public sector? Well, then the answer is no.
Yeah, I'd go back and look at your sick leave policy, guys. If you don't have one, get one in place, particularly with this new legislation that's in place now. I was out with a small company yesterday and they've only 3 employees and the 3 of them have already taken the 3 certified sick days since it came in. Something that you could put, like, say, if you're sick, phone in, don't send a text message. If their leg is broken, they can still talk. Ma'am, you should not be phoning in for them. So put that back on them. And you can say that even though it's understandable you're sick, an excessive level of absenteeism through sickness may not be acceptable. And if you take sick leave, which isn't genuine, that it can result in disciplinary action and potentially lead to dismissal. But always get them to fill out a sickness self-certification form, again, from the health and safety point of view, when they come back to say that they're certified that they were sick. And also what you're getting them to sign at the bottom is, I certified that I was sick on the date shown above, that the information is true and accurate. I hereby give my employer permission to verify it, and that falsification on this official document can result in disciplinary action. So they're less likely to take fictitious sick days if they have to fill in that form. Are staff entitled to shopping days at Christmas?
No. End up. No.
Yeah. One of my employees is accusing another staff member of, oh God, yeah, I mentioned this, of bullying, but the staff member is only telling her what jobs that she has to do and don't throw. You see, again, the interpretation of what's bullying, what's not. Yeah.
So the whole thing here is an investigation, that if you're going to investigate the matter, you've investigated it thoroughly, you've heard both sides, and then in your determination from your investigation that you deem that your employee was only given lawful instruction to your other employee in relation to how to do their job or what to do in their job.
Yeah, in fairness, guys, you're all great. You're all still on there. I'm watching the numbers.
Are they all on, are they? I can't see it.
There.
Yeah, I can't see it. Yeah.
I have a staff member who's regularly has to leave work as kids are sick, and so it's basically to do with their children and dental appointments, etc. Yet expects to be paid the full day when they're off on a half day.
No, I would say no. However, be careful here. Again, as I mentioned earlier on, family status. Are we on notice to any difficulty with any of the kids in particular? If it's continuous and one of the kids is sick, I'd be very gentle how I'd handle that. So just proceed with caution. You need to know the full ins and outs as to why this lady is taking time off work in regards to sick kids. So now it could be just a ruse just to get out of work. But if they're not working, well, then they're not paid. And the other thing is, you need that expressed in your contract of employment.
Yep. I think we've well covered the next one now at this
Yeah,
stage. What is the staff handbook? Yeah, I
Right.
hope we've covered that already. And then how much notice does a staff member have to give if they're leaving?
It depends on how long they're working there. So after 13 weeks, they give a week up to 2 years, and then 2 weeks up to 5 years, and then 4 weeks up to 10 years, and 6 weeks up to 15 years, and thereafter 8 weeks. Or if there's a term in the contract that says you must give 3 months notice after probationary period, well, then you have to give 3 months notice.
Okay. And I will also say, guys, if anybody leaves you, always get it in writing. I don't care if it's your best friend, always get it in writing, because again, if you don't, they could claim that you fired them. Am I right in saying, Billy, it's up to 6 months to take place for a year in exceptional circumstances,
Yes.
and you can get into 2-year salary.
That's it. Yeah.
So that's really important. How much notice do you have to give? Oh yeah, that's grand. Did we cover that? Yeah, how much notice do I have to give?
Notice,
yeah, grand. And then do I have to give bonuses at Christmas?
No.
Okay. Florist work involves a lot of standing. My employee says that it's illegal and wants to sit most of the day.
So when somebody tells me that that's illegal, I ask them straight out, what law are you quoting? Which one? What section in the law are you quoting? Just tell me and I'll look at it. So florist work involves standing. Yeah, so it's not illegal, no. And wants to sit more, no. Now, you can, if there's something wrong with the employee where they need to sit, so you're now providing reasonable accommodation under the Equality Act, that's fine. But if there's no issue there, none whatsoever, well, I would say no, they don't. There's nothing there. But again, you need to look behind the request.
Okay.
Okay.
Only 2 more, guys. So this is kind of a health and safety one. So if you're helping out someone to set up a wedding venue, to run a workshop, for example, and you are not getting paid financially for it because they've asked you to just help out or whatever, and you had an accident, would you be considered as a staff member or attendee at the venue? So in that particular case, you are under a duty of care. So and you have to remember, guys, when it comes to health and safety claims, people will decide who are they going to put a claim in against. Are they going to put it in under with the company who owned the building? Are they going to put it in if it was your employee? If it was your employee that was at that venue, maybe as well. Are they going to put it in with you because you were their employee, etc.? So just always be mindful of that. People will decide who they're, and usually they go after the biggest pockets.
That's it. So if it's at a venue and it's a big hotel, just say the Shelbourne, well, they'll throw the net out over the Shelbourne as well. And it'll all depend on the circumstances and how they were injured in the accident. How did the accident occur and whose fault it was? Is there a contributing negligence here? What is it? So there's a lot in that. You know, you can't, but you're right. There is a duty of care on behalf of the person who invited that person to that venue to assist them, be it an employee or not.
Kind of a similar type of, well, it's here. So just take, for example, that you are doing a workshop, right? And you tell your students to come along and help you. And then if one of them gets hurt, who will be responsible for it?
Well, yeah. So again, there is a duty of care again on you because you've invited them along. Okay.
Yeah.
Again, it depends on what. How the accident occurred, like did the accident, like we've just spoken about earlier on, that it's health and safety is everybody's business. It's not just the employer's
responsibility. Yeah,
exactly.
Yeah.
So it's including there. So if they've done something to contribute to their own downfall, well, you know, it won't be that straightforward for them. So, but the important thing here is to have insurance. That's the important thing, because there's absolutely nothing you can do to stop somebody from taking a claim. Nothing, zero. Anyone can take a claim.
Yeah. And that's our last question, guys. But I would just say on that as well, that's why. So you all, I'm sure, have insurance. But now, after today, please go back and ask yourself the question, am I confident that I've done everything? I have all the right documents in place. I have all the right processes in place to ensure that I've made every reasonable effort to protect my people, to protect my employees, my public, etc. And, you know, we can never guarantee that, you know, an insurance company is or isn't going to pay out. They'll make that call. But what we can guarantee is that we would, you know, give an employer the professional backup and the confidence in the systems that they have in place. So I hope you all found it informative. I hope we didn't scare the devil out of anybody. And look, please feel free to give me a call anytime. Take my number down, and if anybody wants one-to-one consultation, you have the QR code there. So I think that's pretty much it. So we should probably say,
Avril, I should have had a glass of wine instead of a cup of tea after that.
You're back here. I wasn't sure if you were still there.
Well, I have to say, like, it's a lot of food for thought, because do you know what? Like, florists in general are single-handed businesses employing a couple of staff, and it just seems we have so much to do. And now this is more work that we have to do, if you know what I mean. I have just one question. A gig economy worker, is that like a freelancer? So as a regular, so we say in the flower industry, people would employ people as freelancers for weddings every weekend, maybe during the summer or whatever. Would they be seen as an employee then?
They could, dependent upon, so there's a couple of things. So who has the control here? Whose control are they under, right? So I'll put it to you this way. If you say that you're bringing in a freelancer and the freelancer says, yeah, that's grand, I'll do that work and I'll do it at 3 o'clock in the morning, there's nothing you can do to stop that person from doing that work, because they're a freelancer. It's up to them when they carry out the work. Now, are they in business on their own account, or are they in business on your account? The famous case in Ireland at the moment is the Denny case, where Denny contracted people to go into supermarkets and they'd cook samples of sausages and rashers and they'd hand it out, and they had all those people as contractors. And one of the questions the Supreme Court asked was coming in from, and they referred to a case in the States called Silk. It was about truck drivers. Who are they acting on? Are they acting on their own account, or are they acting on somebody else's account? And they found they were acting on Denny's account and deemed this woman to be an employee. Here's the exception. If it's just a one-off and you have contracted in somebody, a freelance, just for that and nothing else, right? Well, once they commit to that and commit to that contract on the basis that you're coming in at 9 o'clock and you're going to leave at 5 o'clock to do so many pieces of work, and I'm going to pay you not for hours, but your fee for that is going to be X, well, then it would be deemed that they are freelancers.
Okay.
Right?
Just to say to you as well, we would do contract for services for our clients as well. So even though they're not employees, we can draft up a contract for services. Would it be right in saying, when I was talking about driving earlier on, would a lot of people who have drivers delivering the bouquets, would they be employees, do you think, in most cases, or would they be
That's a brilliant question.
It would be both. It would be both. So normally the employee maybe on their way home might be delivering, or might go out as part of their job delivering. Obviously bigger shops would probably employ a driver, but most flower shops are small businesses. So normally the staff would be, the employee would be delivering. Yeah.
That's a great question. At the moment, we're waiting on a Supreme Court judgment from Domino's Pizzas. It's a Domino's Pizza case, where all the people, the lads and the ladies driving around and delivering the pizzas, they took a case, and the revenue commissioners decided that they should be employees, and the company appealed into the High Court up to the Court of Appeal, and now it's gone to the Supreme Court that they should be deemed as self-employed. So we're waiting on that answer. So that could be helpful. Yep.
Yeah, absolutely. So because again, that would be very much like in the flower industry, that a lot of, they would employ freelancers in for busy times or weekends when there's weddings on. So I actually see there's a question in the Q&A, or there's somebody, hang on a sec now. Thank you very much. That was excellent. So I have to say, like, really mind for talk, like, so much to think about. So as a retail florist or a studio florist or freelance florist, how do they go then about, like, is there levels within your company as regards what they can employ you to do? So like we say, they only need a handbook done, or advice on how to do their handbook, or they only need advice on contracts, or do they have to take you on a retainer for the year? Like, just to give a little bit of brief outline.
Background, but I can cover that for you. So look, as I was saying at the very beginning, employment law is the exact same whether you have one staff member or 5,000. So we do have like it's a support service, and that really covers everything for everybody. Now there'll be certain things maybe in our software that, like, if you don't have employees, we have a rota planner on that, for example. You might have people who are using rota. Some people prefer to do sign-in sheets, but we have an online clock-in, etc., whatever. But our service for employment law, as I was saying to you, like, would be the general, like, that you've got the documentation done and the advice. And the reason why we do that is because, you know, the legislation, as I was mentioning, has changed already so much in the last year, and you need to be kept up to date at all times. Most of the calls that we get in are, you know, the employees, our clients will have the proper contracts, they'll have the good handbooks, we'll have given them the advice on how to roll them out to staff. So we would like to think that staff, you know, kind of know now where to toe the line, etc. And then clients are ringing us in for general questions, but they'll ring us in for the issues as well. So when an employee, we encourage them to say, look, you know, if somebody comes up to you with a question, you just say, look, I'll be back to you, and I'm going to consult with my.
We lost him. No, I don't think so. No, have we lost you, Avril? Can you hear me?
Are you still there, Avril? Yeah, I can't hear you.
We have picture and no sound. Anyway, we were getting where you were coming from, and I think one of the things is preempting something is better than actually, when there's an issue, giving you a call. You know, is being prepared for this rather than when something happens, then having to deal with it.
Yeah, absolutely. Yeah. Don't. I suppose. Yeah, don't do anything before you ask the question, or don't ask a question unless you know the answer, or don't do, you know what I mean? You know what I'm getting at? Don't go off in your own esteem. Like, I wouldn't go and put a bunch of flowers together. I just wouldn't. I wouldn't know what way to do it. And like, look, there is a way of doing it. Like, you know what I mean? So, and it's the same for everybody. There's a way of doing this.
Every business.
And there's a correct way and there's an incorrect way. The incorrect way.
I have to say, this has been excellent, because it's really, I suppose, it has opened our eyes as business owners to what can happen to your business if procedures and policies haven't been done correctly. And like, as business owners, I suppose we always feel, oh, it'll never happen, or I haven't got time for this and I haven't got time for that.
Yeah.
But when you hear you talking about things, and that's going to cost could cost you 30 grand or 20 grand, or you know, it really is sort of something that we need to be more aware of. Are we back, Avril? She's connecting to audio now.
So earlier on, are you in, Avril?
Yeah, I'm in. Sorry, guys.
Go
back there. Sorry, William, go on, I'll let you continue.
So what I said earlier on is this: just what is the average? So, like, what would you pay a florist per week?
What would you pay? They'd be mostly on about €15 an hour, would it be? Yeah, about €15 an hour.
Or 39 hours.
Yeah.
So that's 585. That's €600 a week, right?
Yeah.
Okay, so that's 2,400 a month.
Yeah.
Okay, so that's for 4 weeks. So just say, for instance, you took on an employee, you didn't give them a 5-day statement and you didn't give them a 1-month statement. Now, I say statement, everyone else says contract. It's not a contract. Contracts must be signed. This doesn't have to be signed. It just has, it has to be signed by the employer, not the employee. So say, for instance, we lose and the adjudicator says, I'm going to award 4 weeks pay for each breach. So that's 8 weeks. So you're looking at now the guts of 5 grand. So tell me this, how much profit is 5 grand?
Yeah, massive.
How much profit is 5 grand? So you've had to give an employee 2 months' wages on the basis that you didn't hand it out. Now, my way of doing that is before they start, you get them to sign it and send it back. And if they don't, the minute they land in the shop, see that there, sign it, sign a receipt, both of them. That's done away with now. You're done. They can't ever come after you for that.
Yeah.
The other thing in terms of, and I suppose we could go on all night with this.
Oh, I know. Yeah, I will wrap it up because we've gone way over time. But anyway, go on.
I didn't even get to answer your question yet, Deirdre. Sorry.
Yeah, because Avril knows more about that. You know, how can we bespoke to different people? That's not my thing, right? Yeah. So there's three things can happen in an unfair dismissal claim, right? One is reinstatement, the other is re-engagement, and the other is and/or compensation, right? So I'm working for you, Deirdre, and you sack me, and the procedure is flawed, all right? And I seek reinstatement, and you sack me on the 1st of January, say, and the case comes up in, say, June of this year, and I get the decision today, and it's found that you did unfairly dismiss me. I've sought reinstatement, I get it, and I get €20,000 compensation. So what that means is, and I keep looking up that way because that's where I have your picture or the videos, right? So what that means is you now have to re-employ me again as if my service is unbroken, and you have to pay me from the period of January 1st up to the date of the decision being issued, plus 20,000 in compensation. So as much as you wanted to get rid of me, now you're stuck with me and you'll never get rid of me. So always think before you put your left foot out, make sure you know where your right foot's going.
Yeah.
Right. Sorry, Avril, I'll stop.
No, you're grand. So just to answer your question directly, so Deirdre, look, we can tailor it to a certain extent, okay? And obviously just always talk to us about it. The reason why we do the model we do is because, going back to what I was saying earlier on, like, you know, you can have the most amazing documents, but if you don't follow the process correctly, then where were you with them in the first place? So that's why and what our ethos is that we want our clients to get on and grow their business, and we're their HR. They've outsourced HR and health and safety. So we will write your letters, and if you need to bring somebody in for a meeting, we'll script what you say at the meeting, and then you've got the added protection through our legal team, that if you were brought to a tribunal, send the papers in to us. Our guys like Billy or William will take it on board. I've seen their case files; they're massive, and they'll represent you on the day. And they'll take all that worry and stress away from you. Just pick up the phone and ring us. And I would say, kind of going back to what William was saying there as well, guys, you have to remember, smaller companies, this will crucify you a lot more than the bigger companies. The bigger companies can absorb it. The smaller companies, ask yourself the question, okay, yes, we work on a retainer. Our clients pay us monthly, and they can do it for different terms, and of course we'll price our services in accordance to the size of we base it on the number of employees, and we're always fair there as well. And the reason we do it in proportion to the number of employees, and it will cover any organic growth, is that you need to go back and you need to look at, right, okay, what we're talking about here is legal requirement and legal compliance for you guys to keep yourself protected and your business safe, and you're not looking over your shoulder for the health and safety officer walking in or for the WRC officer walking in. I was in with a dental practice the other day, and they were after having the health and safety officer in, very small practice, and she proceeded to give me 3 pages of corrective action that they had to get in place. And your one is coming back, the health and safety officer. So that's our job now. They've come on board with us. We have to go off and get that all done for them, get them ready. But we gave them a competency letter that they can give to the health and safety officer to say, look, I'm in the process. I've got Peninsula on board. A lot of them will know us anyway. But look at other little luxuries, maybe that aren't as important if if things are tight, that you have to look at when you're talking about legal compliance, versus maybe a fancy computer or whatever. This is something that you have to have in place, and you'll always have to be up to date with your health and safety and your employment law. So that's why we choose the model that we want to keep our clients compliant all the time. And then whatever the term you do, we don't increase the rate. So you can decide whether you want 1, 3 or 5. We'll try and give as many options as we can. So that's what I would say, like, have the chat with me and we'll work around it. And, some of our clients take on both services. Some of them just take on the employment law. Some of them just take on the health and safety. So we'll absolutely, work around whatever is the fit for the business. To keep
absolutely excellent. You know what? You have been food for thought, definitely for, I'd say a lot of people watching in today. Guys, what I would recommend is take a photograph of the screen. You have Avril's phone number, her email address. I will be sending out an email after this. If anybody has an issue with me sharing your email with Peninsula, please do let me know. And I'll be sending out an email. And for those of you that are watching on the replay, I hope you enjoy the replay. And again, get in contact. These guys are the experts. We can't, because this is actually the reason why we brought this webinar about, was because we were getting questions as a school. What should we do? And we're not the experts in that field. That's not what we do. So like everything, we bring in the experts and we tell you, go to talk to them, or they can tell us how they can help us. So listen, guys, William and Avril and Sarah, I don't know if you're still there in the background. Thanks a million for this evening. We really entertaining. We got a few laughs out of it here. And the beginning now was a little bit like, oh my God.
We have to brush up on that a bit better. Amir, can I just say one thing, Deirdre, before we go?
Yes.
First of all, thank you so much, guys. Great opportunity, and I hope you did get something out of it. But also because of you putting us in touch, you know, we are going to offer a free advice call to anybody who wants to avail of it. Just pick up the phone, ring me, say, and you can even say to me, I'm not interested in your support, but you promised me a free advice call, and I promise I'll hold you to that.
Sure,
and then the other thing is, we will give anybody who does decide, look, maybe I need a little bit of help here, we will give them 10% discount off the services.
Excellent. Great. Oh, we appreciate that. We always, what's it, the discount code KAYSFS, that's our discount code across the board.
Thanks a million, everyone.
Guys, thanks a million. Really enjoy that. And I hope we never need your services.
Thanks.
I don't know, we need to ring them with a problem.
William is in the tribunals. You might see me.
That's it. Yeah, absolutely. Okay. Listen, thanks a million, and have a good evening. Take care.
You too. God bless.
Bye.
Bye now. Bye.